We're joined now by Mr. Bola Daniel, who is a legal practitioner and adjunct lecturer of the Nigerian Law School. He's also a barrister at the Lincoln's in UK. Thank you for coming on this morning.
It's my pleasure. Thanks for having me.
Well, we turn our attention now to the tribunals. Lately, they've been giving judgments, of which people will always be divided on those judgments, especially if it doesn't favor you, or even if it does, you will support it. But you've also been keeping tabs on that, and they're speaking about certain principles they see. We've seen judgments based on card readers, either as a fundamental objective or supportive motions. But haven't seen some of those key tribunal judgments. What do you think of how it's turned out?
All right, thank you. Well, to start with, I would say that so far the tribunal's judgments are fair, except for a few things that I would like to highlight. For example, beginning with the attitude of lawyers in the process, the attitude of tribunal judges, the attitude of all the petitioners across board, as well as the respondents as well. For example, the petitioners in Rivers are celebrating the judiciary, and they are saying that judiciary has come of age because the judgment now has gone in their favor. But the same petitioners in Abia State are complaining about the attitude of the judges, are even casting aspersion, for example, on the judiciary.
But that hasn't been handed down, the judgment, in the governorship tribunal, has it?
I think it has.
Okay.
Yeah, in favor of PDP.
Okay.
Right. And then if you go to Yobe, APP1, PDP are casting aspersion on the judiciary. Now, the lawyers are also not playing a good role, because sometimes and the rules of professional conduct, it's clear that the duty of a legal practitioner is to uphold the rule of law, foster the cause of justice, and not to behave in or exhibit any conduct that is unbecoming of a legal practitioner. When your client loses a case, it is not you. You must not attach emotions to it. And you must not join the politicians in casting aspersion on the judges. Then also the attitude of the judges, you find that tribunal decision in a particular place sort of runs contrary to the tribunal decision in another locus. Meanwhile, the principles applied in arriving at those decisions are the same. So I think that while if you ask for my opinion, I would say that the judges are trying. However, we need to critically look into some of these discrepancies. Even though the law is clear, if you are dissatisfied with the judgment, you have the right of appeal. So you don't have to go to the media, for example, to cast aspersion on the judge. Just go on appeal, argue your matter, and then see how it goes. You mentioned the issue of card reader. The provision for card reader is in the guidelines of INEC. Now, in River State, the decision supported the provisions of the guideline. And in fact, I think the tribunal chairman, in delivering the decision, placed heavy weight on that guideline. I think Article 22 or 28 that provides to the effect that where you find votes exceeding the number of accredited voters on the guideline, then that election will be cancelled. But if you go to a place like Abia, it seems that when the issue of card reader was raised as a fact and issue, the judge took a position that the guideline does not have the force of law. So these are issues of law that I believe that the Court of Appeal and Appeal will be able to look at.
And the legal said it doesn't have a life of its own.
It doesn't have a life of its own. But my opinion is the guideline is a consequence of the powers of INEC drawn from the Electoral Act to bring about. It's just like when you talk about the rules of court or practice direction of the court. Yeah. It has the force of law, because that's what guides the conduct of proceedings in court. In the same way, in election, the guideline guide the conduct of electoral process. So how then can, in relying on the provision of the guideline, how can the court arrive at a decision saying that it doesn't have a code of law? It is strange to me.
Let me even read that part of it. The Court of Appeal in the judgment delivered by Justice Obande Festus in Agbaje versus Ambode declared categorically that the card reader has no life of its own, and as a result cannot be used to determine the results of an election, since it is not contained in the Electoral Act 2010 as amended. So in this case, I think what they're arguing is that well, you can't use it as a fundamental basis or yardstick to disqualify or grant your prayers in the tribunal. But then we had the Delta Labour Party man who was here and said, no, the judge did not say that you can't use it as a supporting factor in your prayers, having met the grounds to challenge the elections at the tribunal.
Right.
And so those arguments, they seem to support and disagree when they want.
Well, if you look at the Electoral Act, the condition or the criteria for nullifying an election, you find it clearly written there. Now, a party with the...
For nullifying or for challenging?
Yeah, like if you're
Okay,
challenging
same, right?
a decision, yeah, you want the court to nullify the election, you find the condition in the Electoral Act, right? Either you're nullifying the election in its entirety, or you're asking for a rerun, or you're asking for certain prayers, but you have to establish these things and they are law. They are guided by law. Now, even when you want to go on appeal against a decision, for example, what will form your grounds of appeal must be facts that are related to either error of law or mixed law and facts. Now, if you are coming up with a ground of appeal and you're drawing your authority from the provision of the guideline, it is strange to me to reach a conclusion that it is not possible for you to rely on that because it does not have a life of its own. It is just like a judge using the inherent powers given to him by the Constitution to make consequential orders. Are you telling me that consequential orders does not have the force of law?
So
That's
what is
the
it that they say that, look, that when judges hand them down, that is their opinion, and then they're entitled to it. So when you get to appeal, they can do whatever they want.
I think maybe because it is novel, it's a new area of law. The guideline, we are just using it now. We just used it in 2015. So we need to find, or we need to get to have the final decision of either the Court of Appeal or Supreme Court on the matter. But I know as a fact that if you are using, just like in INEC, they have guidelines. If you look at the practice direction of court, it has the force of law. If you look at the consequent orders of the court may order the right of a party. But consequent upon that, the court may proceed to make certain declarations to give life, to give support to the effect of that judgment. Now, if you look at Article 2, beginning from 21, I think, right up to 28, you see in clear terms the guidelines. Now, why did we introduce the concept of card reader if it's not going to have the effect and the force of law? Let me even tell you, the substratum of the matter in Rivers Tribunal decision, even though a lot of issues were raised like ballot stuffing, snatching of ballot box, substantial lack of compliance with the act, but fundamentally, heavy weight was placed on the excess votes or so as a result of the card reader. The tribunal chairman stated that the card reader is the primary foundation for determining whether or not an election has taken place in a place and in determining the votes.
So why is it that in some other tribunals, it looks as if they're saying something otherwise?
That is why, if you ask me, I would say, well, we look up to the Court of Appeal or finally the Supreme Court to lay to rest this matter. But I know as a fact that guidelines of INEC has the force of law.